Thank you. Michelle, welcome.
Hi,
and
thank you.
So I wanted to just direct a few questions, if I might. And first of all, just to let everyone know what you do and what your job is and that. How long have you been employed as the COO of that?
So I am the Chief Operating Officer of Human Resources Enterprise within the Department of Administrative Services, and I was hired in December of 2011. So I've been doing that position for a little over 2 years at this point.
I want to just make it clear that you were not there when a lot of these contracts were changed and people were let go, correct?
I assume that you're talking to the layoff that,
yes.
that happened in September. I was not here at that time. That's correct.
Very good. And since that time, have you dealt with any contract changes, or did any of the contract changes occur when you were there? Any of this?
I just want to make sure I understand your question. When you say contract changes, can you help me? I want to make
where
sure.
Folks were moved from non-merit to merit to non-merit, any of those?
Certainly, as a part of our standard process within human resources, we have what's called a classification system. And as a part of that classification system, essentially we have about 800 different classifications. And each time either a new position is hired, or a new position is replaced, or a new position is created, someone leaves, comes, or frankly, if the hiring leader or an incumbent wants their job reviewed, we review the classification. And what comes out of that process is not only the determination of what that job will be classified as, but also that results in pay, that results in a merit or a decision around merit status, and also collective bargaining status, FLSA status, EEO status, etc. So that's a continual operation that happens within. We do about, I want to say around 1,600 of those a year, those classifications, and again, that classification process kind of drives those subsequent decisions. So certainly there's been a number of those decisions happening operationally. Also, I'll just bring forward, I assume this will come up at some point, the confidential employee rule change was something that I was involved in and has happened during my time. So I'm not sure if that's what you're referring to, but I want to be open and transparent and put that out there. So those are kind of the, again, the operational processes happen all the time, and then that kind of rule change as well.
Sure. And then just to be clear too, that you hire for all departments, not just that. You folks are in charge of all these departments. Goes through you somehow.
We are, my entity is involved in per the code. There and the merit process outlined within the code. My entity does have a role in kind of the administration of all merit hires. But the hiring authority, so who actually makes hiring decisions, would be the individual supervisor, the individual leader. So we have a process that I can certainly talk through where we're involved for all merit-based hires, but we are not responsible for the hiring decisions unless, of course, we happen to be the supervisor. So
how does the supervisor work with you?
Right, so for merit-covered positions, they would, all requisitions come to my team. We have what's called an applicant tracking system, which we call brass rings, the actual name of the system that we have. Those requisitions flow into the brass ring system, and essentially then a posting goes out online for a minimum of 10 days if it's external, or 5 days if it's just an internal posting. And then applications come in. Our responsibility then is to essentially screen those applications to the classification that's being hired, to the minimum qualifications of that classification. So again, going back to that system we have where there's 800 classifications, each individual classification has a specific set of essential kind of minimum qualifications that are driven by the roles and responsibilities of that position. Once we have screened the number of applicants that are eligible, those then essentially go on a list that's then, and I'm simplifying a little bit, but essentially then go on a list out to the hiring authority. From that point forward, it's really the hiring authority's responsibility to ensure a merit-based system. That is, from that point forward, they're responsible for the screening and selection process and to make sure that the candidates selected are the most qualified candidate for that position.
Very good. And the idea behind a merit-based system is?
Kind of just as I said, to ensure that the most qualified candidate is hired for that position.
Very good. So if I got a departmental opening over here at Veterans Affairs or Iowa Workforce or wherever, it's not somebody's friend, it's somebody who is well qualified for this position because you've screened them.
Again, we've done the initial kind of high-level screening, but then the individual screening to that job is the responsibility of the hiring authority, and the ultimate decision for who is hired per the merit-based process is the decision of the other. I just want to make sure, because we kind of have a handoff during the process, so I just want to make sure.
So at a certain point in time, it's kind of up to the department.
Absolutely.
And they can probably either take your advice or ignore it.
Well, right, the way we're staffed right now, we're not necessarily providing them advice unless they seek it. But the way we're staffed right now, we are providing kind of a list that meets the minimum qualifications. And that's really where our role ends in the process.
How would you have been involved in the shift from the merit to the at-will? Would you have been part of that then, or?
So to be clear, in 2011, when the administration first came in to office, prior to my time, as I understand it, there was a full review of the administrative rules. One of the administrative rules that came to the team's attention was the definition of confidential employee. An objection had been filed, I believe, I want to say back in the 80s, and so that brought some attention to the team, and they took the time to take a look at that and believed, based on the objection that had been filed, that the definition was written too narrowly. And so started kind of in an effort to review that rule to determine what might be appropriate. Again, I came in, was employed in December of 2011, and so I became involved in that process in early January, or in early of 2012. And do you want to just keep talking about that process?
Sure.
So we put a group of individuals together representing the different entities within DAS to take a look at the rule to determine if indeed we could construct a rule that perhaps was really met what we believed the intent of confidential employee meant. And we did that by constructing a kind of a two-prong approach to define confidential employee. And so we were, there was two prongs to make sure that what we believed was that if you met just one, perhaps that would be too broad. So we wanted to make sure that there were two to try to really get to the people who we believed were confidential and perhaps then should be exempted from the merit system. Those two prongs were essentially to be on the management team of essentially an executive. So see if I can fumble for the rule real quick here, but essentially on the management team of a high-level executive within the department, and to also have a confidential relationship with that particular executive. So from that, and if you'd like me to read the additional rule, I do have it in front of me.
Yes, and just for my clarification, who wrote that rule or who authorized that rule?
So, yeah, sure. Sorry, I apologize. I can certainly talk through that. So again, we had a committee of individuals put together. I was a participant on that committee within DAS who took a number of months, probably around 5 or 6 months, to review and to really consider alternatives around the construction of that rule. And then we took it through the standard administrative rules process. And the rule became published in, I want to say December 19th, December of 2012.
And who wrote that rule and gave it to you?
We created it, sorry, I apologize for not being clear. There was a committee, so there were 6 or 7 of us. I participated in that committee that, as a group, created the rule, or the revised definition of confidential.
Who might have been on that? Did you remember?
Certainly, myself, Director Carroll, Caleb Hunter, Connie Hellman, Jean McPherson. We had a representative from each of the enterprises. I apologize. Let's see if I can come up with everybody. Matt Behrens, Tim Ryburn, Ryan Lamb, and I will make sure I take a look at the list to make sure it's inclusive, but I believe I got everybody, or the majority of the members that participated.
And during those discussions, did Mr. Lamb or Mr. Farrell give you any directive or any discussion as to where the idea to do this came from, this reorganization?
So again,
or they just showed up and said, hey, we're going to do this?
no. Again, I would say the discussion was always centered around that there was a review of rules that took place in early 2011. I will say this was before my time, but I did spend a lot of time on this, so I can speak to what I've heard and what seemed to make sense based on the many discussions I participated in. That it was a review of all of the rules that took place early in 2011, and this was one rule that came to attention because, and I keep referring to it as a rule. It is within our rules. It's actually a definition. But it came to the department's attention because there was an objection that had been filed, and that caused us to give it some more review. I think the department believed that the objection had been filed because the definition was written fairly narrowly. That was kind of the department's analysis of that, and so that caused us to put together the team to re-review the rule.
And file was objection?
It was an objection. No, the objection, I believe, was back when the rule was initially, or the definition was originally put in place as a part of the admin rules process, as I understand it.
What were they specifically objecting to?
Again, as I understand it, and frankly, I don't know if I've seen the actual objection, but the way I understand it was and I can read the original rule to you if you'd like, but the original rule essentially called out just some very specific positions. Several very specific positions, and I think as I understand it, the objection was that it was fairly narrowly defined as it relates to the entire system of state of Iowa executive branch.
And then, in the process of all of this, was ever any money discussed as to payments of any of the contracts that were done, or the shift from at-will to merit? Did any of that ever pass through your office or anything at all?
I'm not sure that I understand the question. There was no money conversations associated with the revision of.
Yes, with the job descriptions or anything. It was just here it is. Here's the confidential employee. This is it.
Right. There were no conversations. Money was not anywhere attached to the discussions around the revision of the rule. I want to make sure I'm answering the question correctly, but this was a process specifically related to the definition of confidential employees. It relates to the merit exemption process, and no, there was no discussion of money.
And since it came up here in our earlier discussion, when your group met to do this reclassification, this reorganization, was there ever any contact with Mr.
Are you talking about the rule process?
Yes.
So the revision of the rule?
Yes.
Yes, we certainly did have conversations with the governor's office as we worked through this, especially towards the end when we were getting ready to, get to the point where we were communicating with department. We were going through the rules process. Frankly, all of the rules, I know I can speak to the rules that I'm responsible for, but I think it's true for all of the rules in DAS. They're all taken to the governor's office before we go through the formal admin rule committee process. So yes, certainly that's one of the steps in our process.
Very good. And I guess just I'm kind of wrap my mind around this just a minute. So we worked through the objections and we wrote the rule. And when did all of this go into effect?
So I believe the rule was formally passed or became official in December of 2012.
And then shortly thereafter, we see this change occur throughout the system then from merit to at-will.
Well, a couple of things, and I actually have a handout. One of the handouts that I provided you with is a Venn diagram.
Sure.
Yes. Our system is I'll just take just a second to talk about this, and then I'll go back to your question kind of on implementation.
Sure.
But our system is a kind of a complicated one, frankly. As you'll see on the diagram, we essentially have 5 different statuses for which an employee may be included, or essentially an employee will be in one of these 5 statuses. So the first one that you'll see will start from the far left and work over to the right. The first category you'll see is contract covered but non-merit. So in other words, they're covered by a collective bargaining agreement, but they're exempted from the merit system. The middle overlapping section you'll see is they're contract covered and also covered by the merit system. The third portion there is they're not contract covered, but are merit covered. And then up top you'll see at will, which essentially means they're both not covered by the contract and not merit covered. So the reason why I think it's important to mention is it's possible, and frankly we have this, where we have people who may have become merit exempt as a part of this confidential process, but may not actually be at will, because they may still be covered by a contract. So I just think that's an important thing to point out. And then kind of the small anomaly we have here is the far circle on the right, which these are, it's a small group of employees who may not be covered by the merit system or a contract, but have special code language which provides for things like potentially due process. So they're almost like their own group of, it's like their own status. It's a fairly limited group. So I wanted to provide that for background. But if you'd like, I can go ahead and talk about the implementation process.
Yes, please, because I know we've heard that some people were forced to sign an agreement that they moved from these categories under duress. And so if I could just kind of have you explain that.
I'm happy to address that. So the rule was finalized in December of 2012, excuse me. And in January of 2013, we began to work with the departments to do the implementation. It was the DAS human resource staff's responsibility to consult with each of the departments in order to ensure consistent application of the rule. So the rule was purposefully written to take into account the varying scope and size and uniqueness of each of the organizations. So it was frankly built to be flexible to meet kind of all the variances we have within the executive branch. And so it certainly wasn't a process where we could just go and say these, X positions are covered. It was an individual, deliberate process in consulting with each of those departments, reviewing each of the organization charts, talking with each of those directors and other executives on their team to understand really truly who meets this definition. We were responsible for making sure that it wasn't over-implemented and also making sure that we went far enough. So it was a very deliberate and very conscious and frankly took up a lot of time because we wanted to make sure that it was done the right way. And so we met with each of those departments, some multiple times, to work through and identify the appropriate people under the confidential employee rule. To your point, at the very beginning, I will certainly be willing to state the letter that we provided, probably, I don't know that I have it, the timing, but maybe the first month or maybe the first month and a half was probably not the most appropriate letter. And certainly I think people were concerned that we were forcing people, which was never the intent. And so we did revise that letter. Again, I apologize that I don't have the dates in front of me, but I can certainly provide you with copies of that letter. No problem doing that.
Yes, let's get copies for committee members of that letter.
Sure. I can certainly do that. So the revised, there was, again, I think it's important to note that there was, the intent was not to force people, but was to make sure that they knew that that role had been identified as being confidential and merit exempt.
Very good. So these department heads then that were given your new order here do exactly what they were doing when they started moving folks around. According to your guide.
We consulted with them, so we met individually with each department and worked to identify, to work through each of their org charts, because everybody's org chart's different. Everybody, directors whose